Well, since we already have a number of participants, I think it's good time for us to start. So let us start. My name is Isabella Szkowska. I'm here joined by my colleague, Nazanin Maksudlu, our senior counsel. The two of us are part of corporate structuring team of Altamimi and Company. You might have heard of our firm. We've been very well aware of Marcura and your operations, and we're really delighted to be here with you today. Just by way of background and to clarify to you why it is that Nazanin and myself will be sharing some knowledge with you. Nazanin has been advising clients for really an extended period of time. She looks into director liability inquiries, responsibilities of managers, directors, specifically, but her area of expertise covers education sector and Iran-related matters and a number of other general corporate matters. We're all very general, generalists when it comes to corporate law, but each of us has some specific areas of speciality. And myself, again, a general corporate solicitor. I advise clients quite a lot in the context of GCC operations, some reorganization mandates, transactional work every now and again, but inquiries about directors' duties and liability are the bread and butter of my advisory hat with Altamimi. So this is why we are here with you today. Nazanin will now take us through the plan for today's session, and we'll start telling you a little bit more about the framework in the UAE in relation to directors and managers.
Thank you, Isabella, and good afternoon, everyone. Thank you for joining us today. So, as Isabella mentioned, in today's session, we will cover the duties and liabilities of being a director in the UAE. And in this seminar, we will cover the following topics. So first, we will look at the sources of directors' duties and liabilities, which is one of the most important parts in order to identify where we need to look at when it comes to directors' duties and obligations. Next, we will cover the general duties of directors under the federal legislations. And thereafter, we will discuss the general duties and liabilities of directors under UAE financial free zones. And in that particular financial free zone, we will cover the Dubai International Financial Center. We will also cover the general duties of directors under Integrated Economic Zones Authority, which is a free zone. And as we understand, some of your companies have been registered there. So we will cover the regulations in relation to directors' duties and obligations in that specific free zone as well. So Isabella will cover the DIFC and the free zone regulations later on in this session. And thereafter, we will cover the specific sort of regulations when it comes to specific sectors. And we have chosen in this regard the director's duties and liabilities concerning the protection of personal data, as we thought it might be relevant to your area and sector. Next, we will discuss what can a director do to limit the possibility of personal liability. And at the end, sort of finally, we discuss, can the company indemnify a director against liability? So at the end of the session, we are going to have question and answer section where you can type your questions in the chat box. But at the end of the session, we will address them. Okay, so the first part, sources of directors' duties and liabilities. So before I delve into discussing the sources, I just want to give you some background information in relation to separate legal personality when it comes to companies in the UAE, the principle and doctrine of separate legal personality, and directors' duties and liabilities. So as you may know, companies in the UAE have separate legal personality. Obviously, it depends on the type of the company, but majority of the companies registered as a limited liability company, companies limited by shares, private joint stock companies, all of these type of companies they have separate legal personality. So what do we mean by separate legal personality? So that means a company can sue, it can be sued, it can own assets, and it can enter into legally binding contracts in their own names. And also, third parties dealing with the company in good faith can rely on the fact that the actions of the directors will generally be binding on the company. So as a result of this principle of separate legal personality, actions of directors and the consequences of those actions are generally for the account of the company they represent. So that means the contract signed by directors on behalf of a company would bind the company, not the director personally. So with that knowledge of separate legal personality of what it means, a question could arise as, so why are we so concerned about the director's duties and liabilities if everything that directors are doing is going to be on the account of the company, not in their personal capacity? So this is because the principle of separate legal personality doesn't absolve directors of their sort of liabilities. And this is where their actions, or also include inactions, fall outside of their authorities, or they fail to comply with their duties. And thereby it would cause the company, its shareholders, employees, creditors, or any other third parties loss or liability. So this is where directors' duties come into focus, and that's why we are concerned about directors' duties and liabilities. So in terms of directors' duties, obviously these are personal sort of obligations and attract personal liability for the individual director in question. In terms of the liabilities of directors, directors are exposed to liabilities can range from dismissal and disqualification as a director to civil claims being brought against by the company, shareholders, or any other stakeholders, right through to potential criminal cases, which can include fines and, in some extreme cases, even imprisonment. So with that knowledge and background in mind, it's quite surprising to us that quite often individuals will accept a director position, a genuine director role, or a nominee, for instance, on behalf of a third party, either a shareholder or an absent director, without fully understanding the duties they will owe as a result of accepting such position. And this is even more surprising that individuals sometimes accept multiple director positions across different layers of a corporate group. Okay, so with this understanding of the separate legal personality and director's duties and liabilities, let's start with the understanding of the sources of directors' duties and liabilities. So the sources can vary depending on the jurisdiction in which a company is registered within the UAE. So as you may know, the UAE's legal system is multifaceted and it consists of different regulatory frameworks We've got regulatory frameworks for mainland, we've got for free zones and for financial free zones. So depending on where the company is registered, different regulations will be applicable. So let's explore these in detail. Okay, so the first source of directors' duties we can find in federal laws. So federal laws, obviously, they are applicable to companies registered in the mainland. And what do we mean by mainland UAE? So mainland UAE mainly refers to the geographical area within the UAE that is under the jurisdiction of the federal government. And it specifically includes all areas in the UAE except for the free zones and financial free zones. So mainland UAE is governed by the UAE's federal law, and businesses operating in this area are licensed by the Department of Economic Development, also known as the DED, in the respective emirate. So companies registered, obviously, on the mainland are primarily governed by the UAE civil system, and the UAE federal laws will be applicable to them. So directors' duties are primarily governed by several key federal laws. So let's talk about these ones. So the first one is Federal Law number 32 of 2021 on Commercial Companies Law, which is also known as the CCL or Companies Law. So this is the main sort of source of legislation regulating the duties and obligations and liabilities of directors for limited liability companies and private joint stock companies. So this law primarily governs the responsibilities and conduct of directors in commercial companies, and it sets out clear guidelines for decision-making, fiduciary duties, and accountabilities. The next piece of legislation that also covers the duties and liabilities of directors is Federal Law number 5 of 1985 concerning the Civil Transactions Law, also known as the Civil Code. So the Civil Code provides a broader framework for the director's duties, and it emphasizes the importance of acting within directors' assigned authorities and avoiding actions beyond their scope of power. The third piece of legislation, federal law, that also covers directors' duties and liabilities, and which is important, is Federal Law number 51 of 2023 on financial restructuring and bankruptcy law. So this law, as you can tell from the date of it, just recently came into force, and it impacts directors' responsibilities during times of financial distress or insolvency. And it outlines the necessary steps to sort of manage financial challenges and to protect stakeholders. And the provisions of the bankruptcy law is outside the scope of this presentation, but however, if you do have any questions regarding the bankruptcy law, please feel free to reach out to us after the session via emails. Okay, so in addition to the federal laws, another source of directors' duties is found in free zone and financial free zone regulations. So as you may know, Dubai is home to over 30 free zones. Each of these free zones offer a variety of benefits and incentives to attract businesses across different sectors in Dubai. Dubai Integrated Economic Zone combines multiple free zones under a unified sort of zone and strategy, and it includes Dubai Airport Free Zone, Dubai Silicon Oasis, and Dubai Commerce City. which they do have a separate sort of regulations when it comes to companies law, licensing, which covers also some regulations on directors' duties and liabilities. Another sort of jurisdiction, we've got financial free zones. As you may know, we have two financial free zones in the UAE, which they have their own, is based on common law system, and they have their own court system as separate regulations in place. One is Dubai International Financial Center and the Abu Dhabi Global Market. The IFC also implements its own set of regulations on companies law, and which is very comprehensive, and it covers specific provisions on directors' duties and liabilities, which Isabella will cover these in detail later on in this session. So understanding the regulatory framework of these zones obviously is very crucial for directors operating within them. So it's very important that directors need to be aware of these sort of regulations and legislations. So in addition to the applicable laws to sort of the jurisdictions where the company is registered, directors must also ensure compliance with regulations specific to their industry. For instance, if a company is in the financial industry, so the applicable financial regulations very important. If a company is in like chemical waste industry, the environmental regulation becomes very important. So in addition to the laws that relating to the jurisdiction, the sector-specific regulations would also become important and relevant in terms of directors' duties and liabilities. Okay, so directors' duties and liabilities are also outlined in a company's corporate and internal documents or constitutional documents of the company. And those can include the articles or memorandum of association of the company, any powers of attorney granted to the directors that would specify certain powers, for instance. It can also, some of the directors' duties and obligations or restrictions can be within any resolutions passed by shareholders or directors, and also any employment or service contracts in place between the individual director and the company. So directors must ensure that they act within the authorities granted to them by these documents, and in order to avoid personal liability. So let me just give you an example here. For instance, entering into significant financial transactions such as loans, credit facilities, and guarantees. So directors in these cases must make sure that they are not going beyond the powers that have been given to them in order to avoid personal liabilities. We will explain that in more detail in other slides. Okay, so that was the part one, sources of directors' duties. If I may to summarize, depending where the company is registered, either mainland, then federal law, free zones, specific regulations of the free zone, financial free zones, then their regulations, and then we will look at the company's constitutional documents, any powers of attorney granted to directors, or any employment contract or service contract between an individual director and the company. So these are the main sources where we can find the director's duties and liabilities. So in part two, let's look at the general duties of directors under the UAE federal law. Okay, so just one point to mention here is that you may wonder, why do we need to be concerned if our company is registered, for instance, in one of the free zones? Why do we need to be concerned about the UAE federal laws? The answer is because there are certain free zones that their regulations are not as comprehensive as federal regulations. So in those scenarios, if a particular regulation is silent on specific provisions in terms of directors' duties and liabilities, then our reference would be the federal law. And also, majority of reasons, they have followed sort of the same principle, apart from the financial reasons, which they are based on common law systems, totally different. But majority of the reasons follow the same sort of provisions. Okay, so first we look at the director's duties and liabilities under the company's law, or CCL. So the primary duties of directors and managers under the CCL are, first of all, directors must not engage in any fraudulent acts. So that's obviously obvious and is very clear. And secondly, directors have a duty of care. What do we mean by duty of care? So directors must manage the company with the care and skill expected of a diligent person. Obviously, the regulation defines what a diligent person is, and it's defined as person having sufficient experience and commitment required in the performance of his work. So this is effectively the main basic standard of care expected of directors of companies under the CCL. And it's very similar to sort of the objective test under the English law. Sort of with the main difference here is that the CCL, under the CCL, there is no subjective test. That means the CCL doesn't require the courts to take into account the sort of experience and commitment of that particular director in charge. So it gives a little bit lower overall threshold when we compare it to the English law. So next, we've got the scope of authorities. So directors should not breach any applicable law or any provisions of the sort of company's constitutional documents, memorandum, or articles of association, or any contract appointing the directors. So that's very important. They should sort of operate and manage the company within the scope that has been granted to them. Another duty is to work within the objectives of the company and not to exceed powers, which is specifically granted to them. So in this context, the CCL specifically prevents any director from carrying out certain material actions, which these are very important for directors to bear in mind. First, entering into any loan agreement, which goes beyond 3 years. Also disposing of or pledging the property of the company is also another material action. Mortgaging the company's movable or immovable property is also very important. Discharging the company's debtors of their obligations, or making any compromise there. Also, which is another point which is interesting to know, is entering into any arbitration agreement. So any of these sort of actions are classified under the CCL as material actions, that it prevents the directors to carry out these actions unless sort of doing any of these actions, first of all, is in the nature of the company, or it is sort of authorized by the company's constitutional documents, any sort of powers of attorney granted to the directors, or is approved by a shareholder resolution. So these are very important for directors to bear in mind. So another duty of a director is to avoid gross error or error in management. So these terms obviously are not defined in the CCL, but we can take some indication from sort of the diligent person definition under the CCL. So in that case, sort of a court would need to consider if the actions or similarly inactions of a director which allegedly amounted to a gross error or error in management fell below the standards that would be expected of a person having sufficient experience and commitment to perform sort of his role as a director on an objective basis. Another duty of director, which is very important, is to avoid conflict of interests. So directors should not put themselves into any position of conflict or take part in the management of any entity which competes with the company that they are a director of, or make any trade or other deals in competition with the business of the company that they are a director of. So in cases of any conflict, so the conflict should be declared. It should be declared at any board meeting that has been sort of convened to discuss the matter in question. And where the director is in sort of conflict, they should not vote on the matter. If the director, however, fails to do so and continue and vote on the matter, the consequence of that would mean that, for instance, the conflicted contract could potentially be annulled, or the contravening director may be required to account to the company for any profits made as a result of not declaring the interest. Okay, so in this slide, we continue with the director's duties under the CCL. And in addition, the directors have a variety of administrative duties under the CCL. And generally, those include maintaining a shareholder register, preparing annual financial statements within 3 months of the company's fiscal year, calling shareholder meetings at least once a year, or upon request from shareholders holding at least 10% of the shares of the company, proposing company dissolution to shareholders if losses of the company reach 50% of the share capital. So here it's an important point to mention, is that given the relatively small amount of share capital that LLCs are usually set up with in the UAE, usually between 100,000 to 300,000 dirhams, this is something that the managers and directors must be mindful of if the company finds itself in a loss-making situation. Okay. Directors must also manage the company during solvent liquidation, and finally, directors must avoid resigning at a time that could cause harm to the company. Obviously, the CCL doesn't define the scenarios in terms of harming the company, and perhaps this is one of those areas that the court would need to decide on a case-by-case basis, but it's another point that directors should bear in mind. Okay, so in this slide, we look at the penalties under the CCL when it comes to directors' duties and liabilities. So as you can see from the table, fines for violations range between 10,000 dirhams to 1 million dirhams. And imprisonment durations for certain offenses can extend from 6 months to 3 years, depending on the severity of the violation. So this would include offenses like false information, unlawful dividend distributions, and false financial reporting. So as you can see, they are quite severe, in terms of financial penalties, and also some extended imprisonment duration. Okay, so next, let's look at the director's duties under the Civil Code. So the Civil Code reinforces, again, certain principles under the CCL, which is, as we have mentioned, directors must act within the authority granted to them by the company's constitution, powers of attorney, legislations, or any employment contracts. And also the authority of a director is sort of assumed to cover full powers required in order to manage the company, unless there are sort of specific restrictions in place in the company's corporate documents. So a question that can arise here is, how do you identify, for instance, if a corporate document, a constitutional document of a company is silent? So the general rule is that in the absence of any specific restrictions, the directors are assumed to have full authority and discretion to manage and to manage the company on a day-to-day basis. And their actions would bind the company, provided that the director make it very clear that they are acting in their capacity as the director of that company. However, there is one point that sort of differentiates the duties under the CCL and the Civil Code, which Civil Code adds another point to it, and which is limits of custom. So obviously, the limits of custom is not defined under the Civil Code. And this is, again, another sort of scenario that the court needs to interpret what they mean. But under the Civil Code, even the corporate documents of the company doesn't specify any restrictions in terms of the capacity and powers of directors, but they may still be liable under the Civil Code for actions that the court would deem as exceeding the sort of limits of custom. Again, definitions in terms of limits of custom has not been provided, and this is something that the court would decide on a case-by-case basis. So just to continue on the director's duties under the Civil Code, again, in the absence of any specific restrictions, a director generally has full capacity to manage the company. And then we've got the binding actions, which is the director's actions are binding on the company if they are acting within their sort of authority as a director. And exceeding their authority can result in personal liability. An example that I can give you here is if a director enters into a contract without proper authorization and the company incurs losses, then the director could be held personally liable for those losses. And that's why it's very important to act within the scope of powers. Also, personal liability can arise if a director is aware of legal violations or their actions were fraudulent or abusive. An example that I can give here is, for instance, a director who misuses company funds for personal gains. Obviously, they can face both civil and criminal liability here. An important point to pay attention to is that the primary responsibility, however, it resides with the company. Unless a claim has been brought against the company, the responsibility is the company itself, not the director. So these are sort of where all the duties and obligations of directors under the CCL and the Civil Code. So while the law sort of sets out the basic duties in generic terms, but it is important to bear in mind that the duties owed by directors of a particular company will be almost entirely unique to that sort of director. And there are certain factors that directors should bear in mind when they are making decisions on behalf of the company. Those factors, I'm just going to name a few for you. It can be sort of the nature of the company, the nature of the board of directors that the company sits on, sort of the internal corporate governance arrangement that they have, the nature of the company's cash flow, annual cycles, profile of the company's workforce, nature of the shareholders, and also how the company fits within an overall group structure will also be important in terms of when a director makes decisions. Okay, so that was the duties under the federal law. The next part, I'm going to hand it over to Isabella to cover the financial free zones and the free zone regulations.
Excellent. I think the UAE onshore regime was a very good entry point to the dynamic of directors' duties and responsibilities. As you will see, really, there are a number of similar themes. And although we are really looking at two different worlds of legislation, the onshore one based on civil law principles and civil code, and really, commercial companies law, while the DIFC is a common law, English-like modeled free zone. There are a number of principles that remain. Some of them would be called differently, but the substance and the reason for those principles to be in place is the same. So let me tell you a little bit about the general duties of directors under DIFC regime. The main piece of legislation that we look at when we think about directors' duties and liability in the DIFC is the DIFC Companies Law. DIFC Law number 5 of 2018. This is the subsequent version of Companies Law. It amended the 2009 regime. And in fact, one of the most prominent changes from the historical version was the expansion of directors' duties. The DIFC realized that despite the fact there is a huge case law that talks about directors' responsibilities and their liability, there isn't much under companies law, and then directors are often lost. They don't really know what their duties are. The current legal regime, in fact, helps us with that, because then it sets out those duties. Literally, it has a number of provisions that talk about those duties. There is the whole suite of duties of directors. And of course, we would be looking at English case law if in doubt, and to the extent that the DIFC Companies Law doesn't give us the relevant answers, but at least the essence of that framework is under the Companies Law itself. So what are those duties? Well, directors need to act within their powers, and that's really very important. Directors cannot exceed the scope of their powers when they act in relation to other stakeholders within the company. But of course, they are not allowed to act in excess of their powers in respect of third parties. And when I think about them acting within or outside the remit of their powers, I would think, for example, about a director executing a loan agreement on behalf of a DIFC company. Let's say that the Articles of Association require entry into contracts by any two directors acting jointly, and in case of one director executing a loan contract, again, that contract should not be really then found enforceable. But again, if then the director goes on and acts upon obligations of the company in that contract without securing signature of the second director, arguably the director is acting outside the scope of their powers. Directors are obliged to promote the success of the company. They really need to focus on what's best for the company, what's best for the shareholders, what will give the most shareholder value, again, within the legal framework that's allowed. They need to exercise independent judgment, and they shouldn't be influenced by the others. Now, this one is, of course, quite a tricky thing because directors can seek advice. They can have strategy management consultancies, tax advisors, legal advisors, valuation experts, any type of advisors, discuss things with them. The board of directors can sit and discuss and brainstorm. But at the end of the day, the director's judgment needs to be independent. It means that if a director then, is in breach of his or her duty, and says, well, that decision was driven by the fact I talked to John and John really thought it was a good idea to change the supplier, that will not be something that will stand in terms of DIFC law. Again, there will be liability upon director for that decision. Directors need to exercise reasonable care, skill, and diligence. Now, what standard the DIFC applies for that standard of care, right, by directors? It's a standard of a reasonably diligent person with general knowledge. So if we really think, okay, well, what would a reasonably diligent person do in a similar situation? Somebody who has the knowledge that we would expect of a director in the same circumstance. This is the question that, again, we would be asking if we want to assess director's liability for a decision, right? So it's a reasonably diligent person. Well, directors need to stay away from situations that could lead to a conflict of interest, and that conflict could be direct or indirect. It can be a director that will be sitting at the board meeting, and let's imagine the director is a shareholder in a supplying company, and the board of directors are discussing entry into a contract with that specific supplier company. Now, clearly, the director has a conflict of interest in supporting. I would imagine the director would really want to secure that contract, right? He's a shareholder in the supplier entity, but there is a direct conflict of interest in the director voting in relation to that decision, because that director, in another capacity, in the capacity of a shareholder, holds shares in the party to the contract that the board are assessing. So really, the way forward would be for the director to disclose the conflict to the other directors, and then either, disclose the conflict and excuse themselves, and the director would say, okay, well, because there is a direct conflict of interest, I'm going to, leave the room now for the discussion about this contract, and then leave the rest of you board of directors to the side, and then I come back and rejoin the meeting. That's one of the scenarios. The other scenario could be for the other parties, by the other directors or even the shareholders, to agree that the director who is conflicted continued to participate in the discussion and the decision making in relation to that contract. Again, it will really depend on some specifics of the case, the number of directors on the board, the number of shareholders, and the nature really of the situation, right? And now, at the end of the day, those waivers do get secured every now and again. Directors are not supposed to accept benefits from parties if accepting that benefit could lead to a conflict of interest. Here, what comes to mind is the following scenario. Let's say that Mark Wura are thinking about appointing an auditor, and one of the board members has a chat with an audit firm that we would call X audit firm, right? The audit firm says to that director, you know what, please vote for the appointment of our firm as an auditor of Markura. Here is, an excellent package for a weekend with your wife in Ras Al Khaimah, this amazing resort, but please vote for our appointment as Markura's auditor. Again, that would be in breach of the obligation not to accept benefits from third parties where that conflict of interest could arise. Again, the paramount duty of directors is to always act in the best interest of the company. So interests of all the other parties need to be pushed aside, and then the focus is what is best for Markura, right, in that specific circumstance. Well, we've already mentioned that, if there is a situation of a conflict, then the director is expected to declare that personal interest and possibly to then really excuse themselves from participating in that decision or in any discussion that concerns that matter where the conflict arises or the risk of a conflict arising is substantial. Moving on to penalties. Well, that's actually a very, very important section of the IFC law, because a director can say, okay, but what is going to happen if I'm in breach of my duties? What risk am I facing? And I think nothing speaks louder than some kind of monetary sanctions or discussion about other sanctions that can be imposed on a director. So the DIFC here have put together the whole list of fines that could be applied by the Registrar of Companies of the DIFC if the director is found in breach of a specific director duty. For example, if a director signs a solvency statement, so states that the company is solvent, although there are no grounds to support it, right? Let's say that the company actually is insolvent and the director signs it to file it with the Register of Companies. The registrar comes to know that the company was actually insolvent, and the registrar can then fine the company. Well, if the company doesn't maintain proper accounting records, there could be a fine imposed on the company, which is actually a fine imposed on directors in a way of 25,000 USD per breach. And please remember, the Register of Companies, if the breach continues, has the authority to reimpose the fine. Now, this slide talks about monetary fines in relation to specific breaches. But there is a generic concept of unfair prejudice. And if the director acts in any way in an unfairly prejudicial, way towards the company or the shareholders, then shareholders or other directors can rely on the concept of unfair prejudice and file a case against the director. So director's liability really is not only towards the Register of Companies, far from it. It's primarily driven by the shareholders. It's liability towards the company, towards the shareholders. This is where the core of those potential claims and risks lie. Now, moving on to directors' duties in a different surrounding, if you like. There is Dubai Integrated Economic Zones Authority that looks after 3 zones. It's Dubai Commerce City, Dubai Silicon Oasis, and Dubai Airport Free Zone. And those 3 are again supervised by the DIES, Dubai Integrated Economic Zones Authority. And general principles of liability that UAE federal law provides for will really find its way in relation to the governance of those companies, because again, those zones are not separate jurisdictions, unlike the DIFC or ADGM. They still form part of the UAE, although they are, of course, separate economic zones. But there is a specific regime that has been put together and that is administered precisely by the Dubai Integrated Economic Zones Authority that sets out a very comprehensive list of duties and responsibilities of directors of companies in Dubai Commerce City, Dubai Airport Free Zone, and Dubai Silicon Oasis. Well, what would those be? Well, to act honestly, lawfully, and promote success in good faith, not accept benefits from third parties, avoid conflicts of interest, avoid providing financial assistance for share acquisition, right? In some cases, provide no false, misleading, or deceptive information to auditors, right? So there is really a comprehensive list, and you will see, I think, very clearly that there is an overlap of some of those duties with the duties we've discussed in relation to DIFC companies. And similarly to the DIFC regime, there are sanctions, there are penalties that could be imposed by that authority. And we've laid those down under really, another slide. And essentially, directors who fail to comply with regulations and that concern those 3 economic zones may face fines. There might be court orders issued against the companies and their directors. And even the license of a company in some severe cases could be suspended or cancelled. Please remember, authorities or registrars that maintain records of companies in those economic zones, similarly to the Register of Companies in the DIFC, have the power to suspend the license or even refuse the license renewal and cancel it. But again, those types of authorities would be reserved for very specific and severe cases. And some examples here, right? Really an example would be a person who signs a certificate related to a merger or a similar corporate action, if there isn't reasonable ground to make that certificate or issue a statement, could be liable, and there could be a fine imposed, right? Unfair conduct towards the shareholders by the company, by directors, again, that might be subject to fines. A very important aspect of directors' duties is solvency. Solvency statements, every now and again, if there is a capital restructuring, let's say there would be a capital reduction in a company. In those circumstances, the regulations require that directors issue a solvency statement confirming that despite the fact the capital is going to be reduced, in directors' view, based on their own diligence, the company is solvent, the company is capable of settling its dues, right? It is still able to pay to its creditors. And that's very important. If the statement gets issued but the company, in fact, is not able to pay the creditors as a result of a given step or transaction, then there could be claims. There could be claims by creditors against directors, right? For example, because they are the party that, in fact, is at loss in such circumstance. Now, if we think about the general duties in the personal data protection context, and I think we would need to move here to another slide. Will be on our, it will be slide yes, introducing part 5. A little bit of a refresher, I think. You would probably be aware that in general, really around the world, there is a lot of pressure on protecting data, protecting personal data, protecting sensitive data. There is a lot of information about each of us in circulation between authorities, between different parties. But at the end of the day, this data is very powerful and it's really all sensitive. And in that context, there are duties that have been imposed on directors and managers of companies under the federal law of 2021 concerning the protection of personal data. Now, what would those really be? Well, we've shared some sample, but in our view, key duties in relation to data protection that directors should be aware of. Directors need to make sure that the company itself has an appropriate technical and organizational standard and takes the measures that are required to protect personal data, maintain confidentiality, privacy, and integrity. So we can, in practical terms, imagine that the board of directors sit and say, okay, well, we really, we have information about our employees. We've got a lot of information about our clients. How do we make sure that nobody hacks the information? How do we make sure that if we process that data, for example, if we transfer that data between our, one group entity and the other ones, that it's done in compliance with local law. And that would then be on the board of directors to make sure that they hire potentially chief information officer, that they approve expenditure to purchase the relevant software that would be required to protect the personal data that the organization maintains, right? So of course, that liability for potential breach of protection of personal data will be on directors. Data, again, of employees would need to, or of other stakeholders in the entity, it needs to be kept in the updated format. And that's, again, directors' duty to make sure that they keep, that the company, the organization maintains updated passport copies of its employees, for example, right? Data protection officer it also needs to be appointed by a business to be that linking point between the authorities, for example, the bureau that looks after data protection and the organization itself. So that's a very, very important set of obligations in today's world where, in fact, our information is really valuable, but it's also truly sensitive. Well, but then the law, that law of 2021 concerning the protection of personal data, similarly to other pieces of legislation that address directors' responsibilities and liability, sets out some penalties, some sanctions for non-compliance with its prescribed framework. for everybody's benefit, there is a UAE data bureau that is the key authority that looks after data protection in the UAE. In the DIFC, there is a data protection commissioner, and there is also a data protection officer in the ADGM. But again, for the UAE, including free zones, apart from the two financial free zones, the ADGM and the DIFC, the UAE Data Bureau is the relevant authority responsible for supervising personal data protection, for example, and processing of that data and compliance with the data protection regime. That authority handles complaints from individuals whose personal data has been mishandled, so inappropriately disclosed, for example, right? And it has the authority to impose penalties on organizations that have breached UAE data protection regime. There isn't a specific list of fines, but there is a general provision that states the Council of Ministers will receive a recommendation from the UAE Data Bureau, and based on that recommendation, it's going to determine the sanctions, the penalties for breach of the personal data protection regime under UAE law. So if there is any concern, if you or any of your employees has a concern about data protection, the authority that could help them is the UAE Data Bureau, headed by its general director of the Bureau. Now, how do directors then limit the personal liability? That's something that Nazanin will address under the part 6 of our session.
Thank you, Isabella. So in part 6, we will sort of discuss what can a director do to limit the possibility of personal liability. So clearly, directors should always act in an ethical and transparent manner, and in what way they reasonably believe to be in the best interest of the company. So as long as the directors follow these, then exposure to personal liability is going to be dramatically reduced. And directors should also bear in mind that in terms of any limits on the scope of authorities. So if an individual director finds themselves in a position where they are not comfortable with the course of action being proposed by fellow director or directors, then what should they do? They should make sure that they raise their objections. That objection should be raised in writing. There are two ways they can do that. They can either address it in a letter and address it to their fellow directors, or where the proposal is tabled at a board meeting, they have to ensure that their objections is evidenced and recorded in the minutes of the meeting. So these are very important. So make sure always, if you're not happy with something that is being proposed by fellow directors, or you have been put under sort of any pressure from the company or shareholders, you need to make sure that you put it in writing, it's recorded, and your sort of objection has been raised. So another sort of area that can cause personal liability is related party transactions and conflicts of interest. So directors must avoid participating in any business which is competing with the company that they are a director of, and they should not trade in the same sector in the same sector of the company without getting prior shareholder approval. So these points also are very important in order to avoid personal liability. Directors should also, as we have mentioned, as you can, see across this seminar several times, we said that you have to avoid conflicts of interest. So if there are any conflicts of interest, you have to abstain from voting on any related matters. And Article 150 of the company's law specifically actually requires the directors to disclose any conflicts of interest, and it prohibits any sort of conflicted director from voting on any related matter. So if you're involved in any sort of transactions that, for instance, your spouse, your children, any related family members are getting benefit, and yourself are getting benefit out of that transaction, you must declare it, and you must abstain voting on that matter. Again, no director is permitted to disclose company data or information, which if they do can lead to compensation or profit repayment. If the director has made profit as a result of sharing data or some secret information of their company, then they might be liable to repay those profits, obviously if the company demands for it. So that was the sort of guidelines that provided in order for you to make sure to stay away from personal liabilities. So always act diligently and act in the best interest of the client in order to avoid any personal liability. So next part, I'm going to hand it over to Isabella to discuss directors' indemnification.
Well, directors indemnification is an interesting topic because, of course, you've heard a lot about the obligations, responsibilities, potential liability. And I can already see that some of you are thinking, oh dear, there is so much to think about. So, that directorship could be in some situations seen as a burden because, of course, there is that liability. Now, there are ways to really incentivize individuals to become directors. Nevertheless, I mean, the point of the matter is that each company needs to take decisions. It needs to be managed. And whether we call those roles managers, which is often the case with onshore companies, or directors, the term that is used predominantly by free zone entities, really they need individuals who will be taking decisions, who will be driving the growth. And of course, we can have both directors and managers, right? We can have, chief executive officer, head of finance, and in addition, the board of directors. Those things are not mutually exclusive. In fact, usually we would have both. We would have the managerial line within a company and the board of directors as well. So the way to ease that exercise, and I think, to say to potential candidates, don't worry, it's not, what you think, it's not there, that directorship is not there to be able to blame somebody if there is a wrong decision, is for companies to say, well, you know what, and sometimes it's actually mentioned in director contracts, because not all directors are employees of companies. Some directors are independent directors, and they may only be appointed on the basis of a service contract, and of course the shareholders resolution, right? The shareholders, and in most cases, in some cases, there is a director's appointment of the other directors. That's the case under ADGM regime, but usually board members appoint another board member if one of them resigns in course of the term or is removed from the board, and it's done on a temporary basis pending approval by the shareholders at the next general shareholders meeting. But then companies would say, well, we will indemnify our directors if there is a lawsuit against them and the judgment whereby they need to pay damages to another party. They pay those damages, but then we compensate them. We compensate our directors, if you like. There really shouldn't be a blanket indemnity. There could be a shareholders resolution that would say, well, you know, for any claims, successful claims against directors of our company, we are going to indemnify those directors. But you need to remember that there are situations where a director is really, you know, taking a decision that is hugely negligent. And then the question for the company is always, are you sure you want to commit to always indemnifying any director for any liability, right, in relation to their actions in their capacity, of course, as director of that company? We're not talking about any other liability by John, then liability of John in relation to a decision, for example, he took in his capacity as director of a given company. There is another mechanism to support individuals and candidates for directorships and to somehow, you know, give them protection. That protection could be provided under an insurance policy. There is indemnity insurance for directors that a number of insurance companies provide. And again, that indemnity insurance could be secured either by a company for its directors or by directors themselves individually. And again, in some cases, depending on the company, on the policy of the company, on the shareholders' decision, directors may request to be indemnified or compensated or reimbursed for the amount they've paid towards their indemnity insurance package. But again, it depends. In the region, not many directors have indemnity insurance. That type of insurance policy is very expensive in the region. And this is something that has been putting businesses off securing it for their directors. Again, it's all about the shareholder value. So there is that commercial aspect to consider. Now, moving on to the absolution of board responsibility, right? The shareholders can approve or confirm board decisions or board actions under a resolution, and it can be done retrospectively. So, you know, the shareholders can say, we, the shareholders of so-and-so company, gathered on so-and-so date, we approve the entry into a contract with, I don't know, Coca-Cola by Marcura in relation to the supply of Coca-Cola drinks to all the Marcura employees that was taken in December 2023, right? I mean, that's just some kind of an example which shareholders can take that decision, and this way they are really, you know, approving and releasing in a way from liability that director. Again, we are looking at the liability towards the shareholders. If one of the shareholders wants to file a lawsuit against the board or a board member, then the board member can say, well, I'm sorry, you know, your claim doesn't stand. The shareholders approved my decision, and therefore I'm not liable towards the shareholders for it. Again, it doesn't mean that there cannot be a third party making, you know, a claim against a director, but at least that director would be off the hook when it comes to shareholders' liability. Well, that absolution could also protect against civil actions, and that's in line with what I've shared. It relates to the potential shareholders' actions. Since shareholders can't waive any third-party rights, right? The shareholders' resolution can only concern rights of the shareholder. Even if the shareholders' resolution says, we approve your decision and release you from any liability towards any third parties, that provision under the resolution would not be effective. Again, third parties can decide, whether they want to file a case against the board or not, and there isn't a way for the shareholders to somehow block that right. Criminal actions, interestingly enough, are really something that is determined independently. So if a given action or a decision by the board has a corporate law element, right, and purely that civil liability or corporate law liability element, the shareholders could really then absolve the board for the past actions through their resolution. But if a board member committed, or the board jointly as a body, right, committed an act that could be subject to liability under the criminal code or the penal code of the UAE, that's a different discussion altogether. This is where the shareholders' resolution, even if passed, and even if it says we release the board and its members of any criminal liability, that part of the resolution would not have legal effect. Again, criminal liability is looked into separately. And going back to what Nazanin has already shared with you, directors could be subject to two types of liability. It can be civil liability, it can be criminal liability, and also they can be liable towards a number of different parties. It's not only towards the shareholders internally within the company, but also there is the whole pool of creditors of other third parties that the company contracts with, for example, of authorities that the company itself is supervised by, that the board needs to answer to. So that role is complex, but by the same token, it's actually really necessary. It's exciting. And as we said, there are ways to reduce that liability, to give a cushion, and also to make sure that there is some kind of indemnity security provided to members of the board of directors to give them additional comfort. On that note, we would like to close the content we've prepared, but we would be very happy to take questions. And we still have 10 minutes. There is a chat box, so please, because it's very difficult for us to activate the sound, we wouldn't want to disturb the technical side of the session. So please feel free to type questions to us. And if you have some questions after the session, I suggest you share them with the individual from your organization who had been in touch with us in relation to the session organization. And we would then be very happy to provide some responses, or to have a call and brainstorm some specific scenarios with you. I'm looking at Q&A. Yes, we've got here, I can see again, I can see some questions. Why is indemnity insurance so much more expensive than other areas? Yes. Is it because of the likelihood cost is so much higher than in the UK, for example? Well, I think, it's the economies of scale. When I talk to some insurance companies, we've learned insurance companies don't really have a lot of clients who would like to secure that insurance. And therefore, really their pricing is very high. It's not very common in the region to have that. If every company wanted to secure the policy for every director they have, perhaps due to the higher demand, insurance companies would be able to then reduce the prices. It's really not clear to us from the standpoint of a local law why those prices are that high. I would understand in common law jurisdictions, there are a number of situations when the director is found liable, there is quite a hefty claim made by another party, and then of course it's fair for the director then for the insurance companies to be worried. But they actually aren't that worried elsewhere. In the UAE, I think really they sometimes imagine that the liability could be easily established, which is not the case because there is still, quite a high burden of proof, and courts have no interest in simply penalizing directors. No, they don't want to undermine the whole role of a director. They don't want to question every decision of a director, right? But it seems like it's really the typical supply-demand situation that has been driving those prices high. Another question we've got here is, what is the precedent for the actual application of the fines and custodial sentences against directors? Is it frequent? Are directors locked up pending cases? Here, of course, the scenario will be different in relation to onshore and DIFC companies, but there are situations where very rarely, so just to address the question, very rarely would directors or managers find themselves in the hands of authorities in prison, for example, really just like that, and stay in prison pending clarification or charges being presented to them, or pending cases. From what we've seen, of course, if the company has a lot of liability, if it's financial liability towards a number of parties, sometimes that's the case. We've seen some immigration breaches, or not actual immigration breaches, but some breaches that authorities were investigating, and managers then being really detained and arrested. But then again, if it happens, very occasional, again, very rare. But if it does happen, then it's really a matter of probably really 6 to 8 hours, and then the individual in question is released and the investigation then proceeds. In some cases, our litigation colleagues are contacted, and then they intervene. They attend the police station, for example, and secure the release, and then the authorities look into the case. So there is a way to get really released quickly, but directors shouldn't worry about them being arrested upon crossing the border, for example. As I said, it happens very rarely. Those cases took place years ago. The UAE was much more prone towards, really law enforcement, and authorities were involved in a number of cases, and they would lock people up and then investigate. That's not the case anymore. They also want to make sure they dedicate their own resources the right way, rather than really detaining some senior officers of organizations while they are still investigating the matter and have no proof. I'm looking now at another question. I guess overriding on paper, these obligations are the same as the UK, EU. So why does the UAE have a reputation for being high risk for directors? Presumably enforcement and likelihood of third-party claims against directors. Lean, that's spot on, right? The obligations on paper indeed are very much aligned in the UAE with those principles we would find in other jurisdictions. I think due to the fact that sometimes, rarely, as I said, but sometimes there are situations when there is a manager or a director of a company crossing the border who is then stopped by authorities, taken for questioning, in some circumstances, maybe, you know, detained short term, but still, this naturally leads to the UAE's reputation for being a high risk jurisdiction. Whereas in fact, the number of cases where the law enforcement would be involved has dropped significantly over the past years. And while we hear about those cases, they really happen, first of all, after an awful lot more time having been spent by the authorities investigating the matter to get to the bottom of it and see if that individual actually is truly linked to the act in question. So it's rare, and even if it happens, authorities now take a different view. They don't want to detain people. They would rather, you know, then release somebody and then essentially say, okay, well, pending investigation, please don't leave the UAE. Sometimes please don't leave the UAE is done in a harsher way. It's essentially that in some cases, authorities maintain a passport of a director, and then naturally, unfortunately, the individual cannot cross the border, right? But again, as I said, very rare. Cases that again I'm thinking about would be immigration. So, you know, if there is a work permit required and it turns out that the authority is, that the Human Resources Ministry are looking into some people working for the organization, and those, you know, employees don't have a work permit, that is considered severe by UAE authorities. And another type of action would be fraud. If there is a huge amount of money that has somehow disappeared from the company, and again, there is, you know, more than suspicion, but there is already some evidence that the individual could be behind that fraudulent act, right? So I think that law enforcement involvement, potential involvement, is something that really makes all of us think there is a higher risk. Whereas in other jurisdictions, very often we would see, well, not very often, but if we do see any activity on the liability side, this would be court cases, creditors filing motion, filing, you know, I don't know, damages claim, a shareholder filing a case against a board of directors or a specific director. So it's more of a civil liability type of circumstance, whereas in the UAE, that criminal liability element is what really instigates a little bit of that fear. Now, just to close off, could it be due to the high rate at which companies become dormant or liquidated in the UAE? Unlikely. There, you know, I still think that this type of liability discussion and a little bit of that fear is driven by potential criminal liability, and then law enforcement authorities sometimes, rarely, but sometimes getting involved. And there is a request also from Srinath that we share the presentation. We would be happy to do it. So internally, please then check with the person who's been kind enough to arrange the session for you from Arcora, and we're more than happy for you to have the slides. You know, we're just an email or a phone call away, and we hope you've enjoyed today's session and know more about the director's liability responsibilities framework in the UAE. Thank you very much.
Thank you, everyone.
Goodbye.
Bye.